What that means.
It's going to be about.
No doubt it will be helpful. Members, the House and Committee on the Alcohol Reform Bill is resumed. Can I just read the preamble? Members, before the dinner break, we were debating the amendment in the name of Honi Harawira, set out on SOP 121. This proposes a new Part 2A relating to the review of ages for sale and purchase of alcohol. Point of order, Honi Harawira. Was the point of order? You're going to speak. You're taking a call. You have the call. Honi Harawira.
First of all, I'd like to thank Mr. Nathan Guy for supporting this SOP. Thank you, Nathan. Most appreciated. Mr. Speaker, I've heard many of the arguments both for and against my SOP for a review of the ages for sale and purchase of alcohol on licensed premises within 5 years of the commencement of the bill. I thank the members, all of the members, for their consideration. But I simply ask, what could be wrong with a review? It's not an overturning of the age for those who support the 1818 scenario. It's simply a review of the situation. And I'm not going to relitigate all of the debate that's been had in the past couple of hours. Excellent kōrero. Suffice to point out that I spoke to a number of MPs who told me after the vote was taken on this issue some weeks ago, Mr. Chairman, and some of them told me that they actually voted for the 1818 scenario, not out of a deeply held conviction that it was the right thing to do, but because they thought that in an environment where 18 to 20-year-olds have so much voting power, that it might be a bit risky to vote against something that 18 to 20-year-olds patently wanted so much. But this issue, cynical, it's also true. And one of those MPs, was a member of the National Party. I won't tell you who. And it wasn't Minister Collins. But this issue, Mr. Speaker, is not one where we should be wavering, nor is it one where we should be necessarily accommodating to people just because of age. I'm comfortable with the votes of those who genuinely think the age should be 1818, but I know that the vote on the night was not what many members wanted. And so I simply want to provide the opportunity to revisit this matter at the earliest opportunity. I did take note of one comment, though, from Mr. Lees Galloway, who felt that he couldn't bring himself to vote for my SOP because he thought any review should cover a wider range of issues. Well, all I can say to that is that if he wanted to put forward some of the other issues, then I would have been happy to support them. But I sincerely hope that he can still see the value in supporting something because it's right, rather than opposing it just because it doesn't cover all of the things that he necessarily wanted it to say. But just coming back again to my first point, Mr. Chairman, this SOP is not to change the law. This SOP is not an attempt to overturn what this House has already determined. This is simply providing an opportunity for all members to reconsider the vote that was taken on the issue of age some weeks ago in 5 years' time. Hoi no kānui tērā māku, kia ora tātou katoa.
The question is, point of order, Honourable Trevor Mallard.
Mr. Chairman, I'd like to draw your attention to what I think is a gap in standing orders and speakers' rulings when it comes to split party votes. And I'd like to refer you to Speakers' Ruling 66.6 from Speakers O'Rourke and Lang, who are distinguished speakers of the House, and 66.7 from Mr. Ian Revel, who I think it's fair to say is a less distinguished chairman of the committee. Mr. Speaker, what it indicates when taken together is that there does not appear to be provision for members who are mainly voting, who are personally voting as part of a split vote, but hold the proxies for a split vote, to call for a party vote on on a particular issue. And I think it was highlighted in one of the earlier votes where, notwithstanding the fact that I was voting for something and that was a declared vote, I asked for and got from the chairperson a ruling that there could in fact be a party vote. And what I'm looking for, Mr. Speaker, is a ruling from you that where a member is holding the proxies for a split vote, they can in fact call for a party vote, notwithstanding the fact that they do themselves agree with the ruling that you have made as to the result.
I'm a little perplexed by the member's point of order in this regard. You call for a party vote, but then if a member is holding proxies on both sides of the argument, why could they not call for a party vote? The member means party vote, not personal vote.
No, I mean, I'll give you a bit more of a hand.
Righto, thank you.
I think if you look carefully at 66.7, what that does indicate, and I will say it is one of the less distinguished rulings in Speaker's rulings, but what it does indicate is that if a member themselves is voting in a way that agrees with the ruling of the Speaker or the Chairman, that they are not allowed to call for a party vote.
They should not call for a party vote.
And so my view is that in fact in these circumstances where there is a split vote, it would be helpful if you indicated that in those circumstances they can. I think you might have just about done it already, but it would be good if you did it in a more formal way.
Yeah, speaking to the point of order, Michael Woodhouse.
Two quick points, Mr. Chairman. Firstly, 66.7 relates to personal votes, and as the Speaker has clarified earlier today, there are only two types of votes. One is a personal vote, one is a party vote, and it's been this party's experience on a number of occasions in the 49th Parliament, in the 50th Parliament, where I, on behalf of other parties, will vote in a way different from that which I would myself vote, because I hold the proxies. This is quite a simple equation. It's articulated in McGee, pages 206 and 207. Any member is entitled to call for a party vote, and the whips can then vote according to the proxies that they hold. That's called a split party. Split vote.
Yeah, no, look, I think I'm on top of it. Yes, I have. And when you look at some depth, there are two contrary points of view here, and I think that's the point that the member is alluding to. And I sort of indicated quite clearly at the end of question time that we want to get the best possible outcomes for this. So in terms of calling a party vote, for the purpose of this piece of legislation, I'm prepared to let any member, whatever proxies they're calling, call the vote. I think that the inconsistencies between these are for another time, and maybe the Standing Orders Committee or a considered opinion needs to be given. But in terms of getting the right outcomes here, I think I understand the point that the member has made, and I'll permit that to happen.
Briefly, by way of summary, I thank you for your conclusion and suggest that both you and the senior government whip could look to the midpoint of 66.7, which does make it clear that that is not about personal votes, it's about party votes. And
also time wasting.
Not at all, sir. This is not time wasting. This is making sure that we don't have things ruled out later and cause a lot of waste of time.
Oh, I'm just sorry to interrupt the member also, but my interpretation of this was that it was to deal with a separate issue which may well have been time wasting at the time, and that is not in the purview of what we're doing here. So I'll put the question. The question is that the amendment in the name of Honi Harawira set out on SOP number 121 be agreed to. Those of that opinion will say aye. Contrary, no. Aye. Noes have it. Aye. Party vote? Yes, party vote. The clerk will conduct a party vote.
New Zealand National?
59 votes opposed.
New Zealand Labour?
I'm voting 27 votes in favour, 5 votes opposed.
Green Party?
14 in favour.
New Zealand First?
8 votes in favour.
Māori Party?
3 votes opposed.
Mana,
1 vote in favour.
ACT New Zealand.
1 vote opposed.
United Future.
1 vote opposed.
Any other votes?
Opposed.
The ayes are 50, the noes are 70. The amendment is not agreed to. Members, the next debate is on New Part 2A and New Part 7. We come now to a group of proposals that will be taken as one debate relating to advertising and sponsorship. These comprise Te Ura Flavel's amendments proposing New Part 2A and New Clause 58A set out on SOP 81, Ian Lees-Galloway's amendments proposing New Part 2A and New Clause 220 and New Part 7 set out on SOP 91, and Dr David Clark's amendment proposing a New Clause 220A set out on SOP 115. Ian Lees-Galloway, you're seeking the call. You have it.
Thank you, Mr Chair.